Generally, a criminal defendant is entitled to a jury instruction on a mistake of fact defense when the mistake negates the existence of the mental state or mens rea needed to commit the crime. Consequently, a defendant may assert a mistake of fact defense to the crime of rape based on the defendant's mistaken belief that the victim consented to sex. In Director of Public Prosecutions versus Morgan, the House of Lords considered whether a defendant charged with rape had to prove that his mistaken belief of a victim's consent was both honest and reasonable. On August 15, 1973, William Anthony Morgan, an officer in the Royal Air Force, invited 3 members of the Air Force back to his home to have sex with his wife. After the men agreed, Morgan told them that his wife might fake her lack of consent by resisting, but that she in fact needed to resist and struggle to get turned on. When Morgan and the men arrived, the wife was asleep. The men then woke her up and dragged her to another room where each of them held her down and had sex with her. Subsequently, Morgan and the men were arrested and charged with rape and aiding and abetting rape. At trial, the men claimed a mistake of fact defense, arguing that they honestly believed the wife consented to sex. The judge then instructed the jury that if it found that the defendants possessed an honest and reasonable belief that the wife consented to sex, it must find the defendants not guilty. Following trial, the jury found Morgan and the men guilty. The defendants appealed to the Court of Appeal, arguing that proof of an honest belief alone that the wife consented was enough to negate the necessary mens rea for rape. The Court of Appeal disagreed and affirmed the convictions. Morgan and the men then appealed to the House of Lords.